Mr. Harvey. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was parked and observed a road rage incident occur. The officer observed the defendant's vehicle laying on his horn and speeding up to cut off another vehicle. The officer observed the defendant slamming on his brakes, and the driver of the other vehicle then attempted to drive around the defendant when the defendant cut her off again and slammed on his brakes, nearly causing her to drive into a ditch and nearly causing an accident with other vehicles. The officer then initiated a traffic.
Road rage may feel personal in the moment, but legally, it becomes everyone's problem. Notice the judge doesn't need an actual crash to move forward. The near miss alone establishes probable cause. Quick question. Should reckless emotional driving carry harsher penalties?
Stop and pulled into a nearby parking lot.
Mr. Harvey, I'm going to find that there's probable cause to go forward with your case. Patience. Patience when driving. And I'm going to have you sign a document promising me that you're going to exercise this patience and not drive in this manner again. And if I find that you do, I'm going to put you in jail. Do you understand? How many times do we have people on the road that sit there and get shot because of the incidents? Like, don't drive recklessly. File those conditions like we did in the other case.
Yes, Judge. Yes, Judge.
Harvey, we were going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll then have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Wait, does he have a Texas? Can you run his license, please?
Expired. I see eligible on RN. I can run it again.
Please. If you do not have a Texas driver license, then do not drive. I will have you sign an affidavit today with me promising me you're not going to.
That right there, a bond warning. Many defendants think it's just courtroom talk, but violating bond conditions can land you back in jail instantly. Let me know in the comments. Should judges be stricter about enforcing these?
Drive unless you have a valid Texas driver license and liability insurance. It is your responsibility to reach out to DPS to figure it out. Do you understand?
Yes, Judge. I see eligible on our end.
Okay, I'm going to have him sign it, and then if you do, if you have a license and liability insurance, you can drive. If you don't, then don't. If I catch you doing it, it's not going to go well for you. You understand? Okay. You were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is that it looks like you're on probation for a felony retaliation case, which is now set at no bond. So we're going to do probable cause here today. If there is enough.
I'm sorry, I can't hear.
You're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide your lawyer today. But for now, we'll do probable cause on your DWI second. You're facing up to a year in jail and or a $4,000 fine.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of an alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, and the defendant refused to do the one-leg stand. The DIC was read and breath was consented to. The results were 0.139 and 0.146.
All right. Have you seen whether she has a valid Texas driver?
It's not eligible, Your Honor.
All right. Ms. Gutierrez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. It is a condition of your bond, and you will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody, but if you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in this state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. You understand?
Okay.
No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk with this person to figure out how we go forward with the case. All right, come on, we'll have you sign this and then we'll have you sign your conditions, man. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
Clear street racing isn't just Fast and Furious cosplay. Legally, hitting a 100 mile per hour can convert a simple ticket into jail time, vehicle impoundment, and long-term license consequences. Be honest, should first-time racers get mandatory jail?
Cannot afford one. One will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer
Say 40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour, and both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted, and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
Not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every time you drive, it's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive. Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Yeah, can you file no racing, reckless driving, and all that, please? Yes, Vic.
Okay.
So you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, Judge. On December 28, 2024, the officer was dispatched to apartments in Harris County, Texas, in regard to a single vehicle accident that hit the mailbox of a residence. The officer observed the defendant's motor vehicle with heavy front end damage, but did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill that came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact at the residence, one to make sure the motor vehicle was not stolen and one to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in an...
Whoa.
Yes, Judge. It was because they had...
Whoa.
Yes, the vehicle was damaged and he wanted to make sure the driver was okay. So he announced himself and went into the residence because the door was wide open.
Wow.
And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said the car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 to 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle was hit. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So are you telling me that he did stay though?
No, what happened, Your Honor, is that he struck the mailbox at the apartment, and the defendant said that he called his insurance. No one came to the scene, so he walked home. And the officer, when he arrived, saw the empty...
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stated he called. And then after that, he walked home because no one arrived on scene. And then that's when the officer arrived and saw his empty vehicle damaged, and then he found a utility bill in the ID.
I have so many questions. Let's do this. I'm going to appoint you a lawyer, or you have a lawyer, right? Let's do this. I'm going to hold off on finding probable cause at the moment. Let me wait for your lawyer to get here. We'll revisit PC and here momentarily. Just go ahead, take a seat for me if you don't mind in the jury box. Yeah? Let's wait for your lawyer to get here and then we'll go forward. Sir, you were charged with unlawful carrying of a weapon and you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27th, 2024, the officer observed the defendant's vehicle failed to maintain a single lane and veering over the left lane on 3 separate occasions. A traffic stop wasn't conducted, and the officer made contact with the defendant, the driver of the vehicle. The defendant advised he was unlicensed and that the motor vehicle was not insured. The officer observed a strong odor of marijuana emitting from the passenger area of the vehicle, and the defendant voluntarily produced a partially burnt marijuana cigarette and stated it was the possible source of the smell. The officer conducted a search of the defendant's identifying information, which yielded an open felony warrant for continuous violence, and a search of the defendant's left jean pocket yielded a clear plastic baggie containing a green leafy substance. The substance was identified as marijuana based on training experience. The defendant's motor vehicle was searched incident to arrest and yielded an unholstered AR-15 pistol on the front.
AR-15?
AR-15 pistol, Your Honor. And the defendant acknowledged ownership of the firearm and stated he used it for protection since his brother is a famous rapper.
Find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. Do you understand? You do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in this life. I don't care where you got to go. I don't care what you got to do. If you don't have a license and liability insurance, do not drive. Do you understand? How old are you, sir? What do you do for a living? Why?
I don't work.
How do you support yourself? How do you support yourself?
My brother supporting me out. I ain't go out looking for a job yet.
It's time. I will provide you a lawyer today, but it's time to get a job, a full-time job. When you have too much time on your hands, you become self-destructive. Not here. Do you understand? All right. Do you mind giving an application, please? I need you to fill out an application for me. I'm going to have you sign a receipt of Victoria. I'm going to have you meet with Fleischer for your bond conditions, and then we're going to go. I'm going to get you on the right track, Mr. Galden. Come on. Good morning, ma'am. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are in a dating relationship as of 6 years. And on December 28th, 2024, the officer is dispatched to a disturbance at a residence in Harris County, Texas. The officer met with the complainant who stated he was assaulted by the defendant at around midnight that morning. The complainant stated he and the defendant had been at a comedy club and the defendant was drinking. An argument ensued and the complainant began gathering his belongings, and the defendant punched the complainant in the face with her left arm, making contact with the center of his face. The complainant said the defendant also slapped him with an open fist on his right cheek twice, causing pain.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with the case. Do we know whether he wants to have contact or not? You guys reached out to him?
Rip was attempted this morning, but unsuccessful.
Okay. Because I don't know what this person wants, I'm ordering you not to have
We have
contact.
a contact or no contact.
Stop. Don't say anything. I'm just telling you what the expectation is so you know, because if you violate these conditions or if you pick up a new case, I'm going to revoke the bond. We'll put you in jail. No more PR bonds. So no contact, no weapons. There is a protective order that has been issued in this case. Get to know it, because if you violate the protective order, they can file additional charges against you. Do you understand? So what we're going to do now is I'm just going to be signing a reset with Victoria. We'll have you take a seat in the jury or wait for your lawyer to get here.
He's He's not gonna come. They've already contacted you guys and let you know he's out of town and he'll be back on the 9th. They said I just needed to come and sign my bond conditions.
Okay.
It's Maverick Ray.
Contact and no weapons.
Yes, Judge.
All right, so what we'll have you do is we'll have you just take a seat. We'll have you sign a reset and I don't know, perhaps did you hear from Maverick at all?
No. They did try to reset it, but I said there may be bond conditions for her. to
Did they
sign.
give you a good date?
No,
Back on the
I said
9th.
Take a date 2 months out, and if it didn't work for them, they could.
Got it. Okay, so we'll have you sign a reset and we'll just have you take a seat at the jury box.
Yes.
Please. Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did standard, what's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory, what happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The
He had
defendant,
expired registration, right?
no, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there are other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there are other vehicles.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here elucidated is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from many other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information. And I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps well, I mean, I don't want to speculate, and you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
right, but you got to articulate facts as well, right? So according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for failure to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
Was it 545.460? Isn't that it?
Fleming, yeah, Fleming, Hardin.
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely, or that there was
Judge,
anything
I
unsafe
also
about it.
have the list of, where under Texas law, where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go?
Oh, yeah.
Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time,
Yes, sir.
right? And then give you time to take a look more. So if you need to, you too as well, if you want to try to find a case law, let me just go through because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure. Good morning. Great to see you. How are you? Always a pleasure. right.
Pleasure's always mine.
Mr. Barajas, you are charged with 2 counts of assault of a family member. You're facing up to a year in jail and or a $4,000 fine on each. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you have the right to have an attorney present, if you cannot afford one, one will be appointed to you, sir.
It's my understanding that the state's going to dismiss one of the, well, it's the same, they just refiled it.
Ah,
That's my understanding.
okay. Good to know. Thank you. Sure.
On December 29th, 2024, the officer was dispatched to a residence in Harris County, Texas, and was met at the front door by the complainant. The complainant stated that I apologize, Your Honor. The complainant provided a statement and brought the officer into her kitchen, and the officer was able to see redness on the upper left side of the complainant's face near her eye. The officer also observed on the complainant a small laceration and fresh blood. The complainant had tears in her eyes and stated that the defendant and she had been in a dating relationship for on and off for 6 years, and that in the morning, the defendant and she got into a verbal argument about various issues, and the defendant became irate due to her confronting him about the issues, and he started belittling her and calling her derogatory names. The complainant then stated that when they were arguing, she responded by insulting the defendant back, and then things began to intensify. Eventually, the defendant charged at the complainant, and the complainant stated that the defendant slapped her with an open palm across her face, throwing her backwards onto the bed. And as the complainant attempted to cover up her face by turning on her stomach, the defendant punched her in the back 3 times with a closed fist, and the complainant did feel pain from being slapped and punched in the back.
Okay. Mr. Vara, because I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection. This identifies Ms. Alvarado as a protected individual. You cannot commit family violence.
Sorry.
It's okay. It's not a big deal. Are they prescriptive?
Yes, sir.
Back on. Okay. I want you to understand that I'm issuing a protective order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, Your Honor.
If you violate this, the state can and will file a violation protective order against you, and it's one of the worst cases you can pick up. Just don't have any contact, don't have any weapons, and you'll be fine with us. Got a great lawyer. Listen to him. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you have to stay in contact with him. If he comes back, tells me he can't get a hold of you because you've taken off, a warrant will be issued. You pick up a new case, a warrant will be issued. It's not hard. Do you understand? Do you understand?
Yes, Your Honor.
Okay. We're going to have them file all the documents. We'll have you sign it, and after that, you'll be free to go. Okay? Do you want a PR bond?
I just didn't want to fight too much this morning, but
Of course,
Yes, Sergeant.
please. I just see the stuff from 92. That's all I see, right? Is that it? Okay, I'll grant you a PR bond, but understand, this is the only one I'm going to give you. You become a danger to my city, you become a danger to my community, I'm going to yank that PR bond and I'm going to make it high. You understand?
Yes, Your
It's
Honor.
not hard, all right? Okay, there's a ton of paperwork we're going to have to do, so just pick a date with Victoria and then you're good. Don't leave until you sign all the paperwork, Mr. Barajas, okay?
Continue.
Okay. You too. Sir, you were charged, do you speak English?
Yeah.
Yeah, no.
John.
Better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turu Biartes, Turru.
Thank you, Your Honor.
Sure.
The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat, and the defendant admitted to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with the case. Have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bonds. Do you understand, sir?
I apologize, it's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset. Victoria will give you 30 days. But I'm going to have you also take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please.